Thank you. Please be seated. We're here for oral argument in case number 1, CACV 17-0211, Gregory Cook versus Cynthia Grebe et al. Council would remind you that these proceedings are being video and audio recorded, so we ask you to please identify yourselves and your clients as you begin your arguments. Each of you will have 20 minutes, which you're not required to use all that time unless you, if you don't need to. But the appellant's counsel, you'll be responsible to watch the clock and retain as much time as you would like for rebuttal. Also, please keep in mind we've read the briefs, and we've also conferenced the case this morning, so we're very familiar with the overall procedure and basic facts of the case. With that, counsel, you may proceed.
Good morning. I'm a little under the weather, so if I'm not talking loud enough, let me know, because I can't tell one way or the other. Did the court have any specific questions on issues for the appellant?
Just jump right in.
Okay. We're appealing the limited issues on the award of attorney's fees. The attorney's fees were awarded pursuant to 12-1103, which is the quiet title statute, and the parties are in agreement that on the quiet title and the adverse possession claims that fees are recoverable under that statute. That's not in dispute. What is in dispute, though, is this litigation also involves several tort claims. Mr. Cook had a private nuisance claim, and Ms. Grebe asserted counterclaims of trespass, conversion, and unjust enrichment. Cook prevailed on the private nuisance claim, which led to an injunction forcing Grebe to be responsible for cleaning up the property. Cook also prevailed on the trespass claim at trial. The conversion claim was dismissed on summary judgment, and the unjust enrichment claim never made it to the jury. And so
she got an award for fees under the quiet title.
Correct.
Provision. She had tendered $5 and a deed. It hadn't been accepted, and so the court awarded her fees.
The court awarded fees, and the court determined
less than she had wanted.
It was less than what she'd wanted. The court determined at trial, because Grebe prevailed on or Cook failed to prove adverse possession, and Grebe prevailed on the quiet title, which is really the same claim. Right. That for that purposes of that statute, those fees were it was directed counsel to file an application of fees. The argument, though, is that appellees are going to argue that that the quiet title claim, the adverse possession claim, was the thrust of the litigation, or that the claims were so intertwined that there was no way you could disseminate which claims the fees related to which. One thing that also should not be in dispute is that on a private nuisance claim and all the tort claims, you can't get fees for that. Those are not awardable, and they have different elements of proof and different elements of damages than the quiet title. Quiet title, you get equitable relief. The court says yes, you're the owner. The adverse possession claim, you get injunctive relief forcing them to clean up the property. But trespass leads to monetary damages. The conversion claim leads to monetary damages. And they were seeking significant monetary damages, which they lost on. So the fact that, they're claiming that they couldn't, that the fee application, they couldn't take their fees and say, well, these are the claims that were, this is the work we did related to the title, and this is the work we did related to the tort claims, and we're not seeking those fees.
But counsel, it seems like that argument you're making right there goes to the amount of the fees award rather than to the determination of prevailing party. Let's back up a little bit. What does this 1103B essentially says? That the prevailing party in a quiet title action.
Yes.
Did we only had one quiet title action here with two claims.
Yes.
Adverse possession, quiet title.
Yes.
Such. Would you agree with me that was the action, or what in your view? What's the definition of an action?
Well, it's even if you have a blended action, let's say you have a contract claim which gives rise to attorney's fees under 12-341-01, and you assert a tort claim along with that, you don't get fees for the tort claim. The law is pretty clear on that.
Understood. But it seems that what you're suggesting is that 12-341-01 case law needs to be grafted in or imposed upon, that we need to adopt that here.
Actually, it already, the factors.
You're saying the factors are that's already decided?
Yes.
By what case? In the context of, specifically in the context of a quiet title auction.
It's the Scottsdale Memorial Health Systems.
Okay. Back from 1990.
Essentially, the factors for determining an award, the court, Arizona courts have just uniformly adopted the factors relevant to the 12-341-01 claims, and Arizona even went a step further and adopted those reasonableness factors related to a private contract. That was a recent case last year that was decided. So 12-341, the factors control what goes on, and there's different claims. It's a claim for a quiet title. You can't backdoor in negligence claims and then seek fees for that.
Understood. I'm still not. I think if we could break this down into three areas, and correct me if I'm wrong on these three areas. It seems like in any, whether you're talking about breach of contract or 12-341-01 or this statute or perhaps other statutes, you have three stages. The first stage is who prevailed in the action, and that could be true in a contract case too, even a binding contract. But who prevailed, right? That's the first step.
Yes.
Who prevailed in the action. Then the second step is if one party prevailed, which, and there generally is one party or the other that prevailed, then should the Superior Court even award fees? It's a discretionary call, right? That's the second point. I don't think that you've challenged the court's discretionary decision whether to award fees here on appeal. Am I correct on that?
I am not arguing that the court doesn't have discretion
to award fees, because I'm on step two. Okay, that was the step two. And then step three is to challenge the amount of the fees.
Correct.
The amount. And you appear to be challenging that on appeal, although I'm not sure that you made that same challenge in the court below. But that...
Well, I made the challenge that they were seeking fees for claims that were not related.
And to what extent? On that point, that's good. I mean,
okay,
I understand.
For example, I filed a motion for summary judgment on the tort claims. I won. I got one dismissed.
Right.
Okay, but then they're seeking fees for responding to a motion solely on tort claims, and on claims they lost.
How do you know they're seeking fees? Okay, they saw it in their application, and maybe that was error to do that, but I don't know if there was a motion to strike the affidavit of fees or anything filed or an evidentiary hearing requested. I mean, the court cut it down by 40%, I believe, or approximately 40%.
Yes, but the court also didn't grant oral argument. The court didn't explain why, and under any circumstance, no party argued that it should be only reduced by 40%. They were seeking the full amount, and I was seeking, part of the problem is if you read the rules going back to China doll, is that you're supposed to allocate fees. And I've had to do this before where we didn't win on claims and take out things and removed items that we're not claiming these fees. That's the responsibility of the attorney seeking the application, the party seeking the award of fees.
I understand your point there. It's a fair point. But are you saying that goes to my prong 1 or prong 3? Is that goes to the amount of the fees, or that's not relevant to prevailing party in my view, because the statute specifically says in an action you prevailed in an action to quiet title. Here we only have one action to quiet title.
I don't think the legislature's intent was to include tort claims, because you could.
I'm not saying it could turn tort claims. I'm saying that's what the legislature said, the prevailing party in a quiet title action. I mean, regarding if you had 10 other claims or 100 other claims, would it matter?
Look, the legislature drafts rules and then we have to figure them out. It also says that the plaintiff may recover. Well, they weren't the plaintiff, but they did bring the claim. So I'm not going to argue. I'm not going to come before the court and say the plaintiff shouldn't recover. Or they weren't plaintiffs.
Because our courts have construed that as either party.
And I don't think that the legislature has been adamant about you don't get attorney's fees in tort claims. And Rule 68 is specifically designed to make offers of judgment regarding tort claims and penalties related to that. Rule 12-34101 recently put in the fee shifting, where if you don't prevail on the offer, or if you don't accept the offer and you don't receive more at trial, then you're not prevailing party. The prevailing party is the person who made the offer. That's a recent change to 12-34101. And in the Arizona Power Products case, which is cited, the court said that applies to commercially entered into contracts that include attorney's fees.
Isn't quiet title cases, aren't they a different animal, so to speak, that you're not going to have damages?
Well, you're not, but
there's no damages at issue in a quiet title action, strictly speaking.
Strictly speaking, yes, but there were torts with economic damages in this case.
Understood.
So the torts, and for whatever that balance is, that time spent on those tort claims that were unsuccessful, my client should not be tagged for any portion of those. And the application, as submitted, you can't delineate between what is this amount and what is that amount, and that's what's required under China doll to do. I'm going to tap out and reserve my time. Thank you.
Thank you.
Good morning. Benjamin Gottlieb for John Meadows and Cynthia Grebe, the appellees in this case. As your judges have pointed out, today we're here to decide two issues. The first issue is whether the trial court abused its discretion in determining that my clients, Mrs. Grebe and Mr. Meadows, were the prevailing parties in the underlying litigation. And the second issue is whether the attorney's fees were either excessive or unreasonable, the attorney's fees awarded. As it relates to the first issue with respect to who was the prevailing party, the legal standard on review is abuse of discretion. And so the case law is clear, and I don't think there's a dispute over this. The case law is clear that the trial judge has substantial discretion, having presided over the entirety of the case, to determine who the prevailing party was. In this case,
Isn't it clear under 1103B that you're going to have a prevailing party on a quiet claim? Either going to quiet the claim or you're going to have the adverse possession?
That's correct. Yeah.
So,
And Judge, I would even take it a step further, and I view the entire lawsuit as a quiet title action. I understand that there were other tort claims that were thrown in there, but I think one needs to start this analysis by looking at the pre-litigation 12-1103 quiet title letters. In those letters, the only...
Counsel, let me stop you there. So go, just to clarify, I think that's an important point, but you're saying that really then a quiet title action is no different than a breach of contract action under 12-34101, where you have tort claims tried together with the breach of contract action, and then you would then look to the totality of the litigation test?
That is what I would contend, and just like the cases say where contract claims are intertwined with tort claims, you can seek attorney's fees even if you don't recover the full spectrum of relief that you were asking for, provided that you accomplish the result that you were seeking in the litigation.
To what extent do we know that the court followed? What test did the court follow here?
Well, the court didn't say, but I would contend that the court followed the totality of litigation test. From the research I've done, there's really three different tests that the courts employ. One is the net judgment rule. That's essentially when you have competing monetary damage claims. I think it was the Trollope case from the early 1970s by the Arizona Supreme Court. That case said that when there's competing claims for damages, the net prevailing party is who is ultimately the prevailing party for purposes of attorney's fees. Well, that clearly doesn't apply here because we're dealing with quieting title to property. You have the percentage of success method that the court employs. Under that test, you're basically looking at how much in damage did the claimant seek and how much were they actually awarded, and then you try to fashion a pro rata or a commensurate attorney's fee award. Again, that doesn't apply because we're dealing with a quiet title action, not monetary damages. So really you're looking at the totality of litigation test where you had varied claims brought. But what I would submit to the court is these claims were not unrelated or distinct. They all came under the same common nucleus of facts, or the same operative of facts drove all of the claims, which was the allegations by Cook in this case that he had maintained the Grebe property for 20 years, and he had removed portions of the roof and so if we go through each of those tort claims, they all actually stem from the same facts that drove the quiet title action. And in the China doll case, it makes it very clear, which was I think it was cited to by both parties as applicable in this case. The China doll case makes very clear that when you've accomplished the result that you saw in the litigation, attorney's fees should be awarded even on unsuccessful related legal theories, and at best that's what you have here. But what I will add to that is that the court didn't grant all of the attorney's fees. The court substantially discounted the attorney's fees by I think around 40%.
Hypothetically, let's say that I know Mr. Cook prevailed on the private nuisance claim, correct? I mean, just for argument's sake, say that there was a substantial damages award of $500,000, just for hypothetically speaking. Would you still contend that you would be the prevailing party under the totality of the litigation test?
You're saying
if you prevailed on your quiet title action? And I use that. I know I think you and I are viewing the word action a little bit differently, but I'm saying if he would have obtained a substantial monetary judgment in addition to the injunction, if you will, to clean up the property, would your client still be the prevailing party under 12-1103?
I think that would be a different case because it sounds like the hypothetical you're proposing is that there would be distinct and separate monetary damage claims.
Right.
And so I think you'd have to perform a different analysis in that case, and it would just depend on the totality of the litigation. I don't know all the specifics, but I think you could potentially have a different result there in that case, but that's not what we have here.
I'm just thinking what I view as to understand the legislative intent, because it's not 12-34101. They don't use the same language. It doesn't say arising out of contract. It doesn't say arising out of contract. And of course, there's a lot of litigation that spawned for what is the meaning of arising out of contract. Here, it just says an action to quiet title to real property. Period. End of story. That's what it is. An action to quiet, and the prevailing party in that action is entitled to seek. The prevailing party is entitled. Okay, right. So, again, how does the court? I'm seeking direction from you. I guess it's how does the court, picking up a quiet title action, get that right every time with consistency, applying the same test each time?
Well, I think the court has to look at is it a quiet title action or is it something more? Here, both sides agree this was just a quiet title action. If you truly have a case where there's separate and distinct claims apart.
An example. I mean, because a lawsuit by necessity, everything needs to come out of a common nucleus. I mean, you don't just join claims that are.
Yeah, no.
I think I'm going to sue you for the for the personal injury accident with my quiet title.
I'll give you an example that I have encountered in the past. So let's say you have a quiet title lawsuit that's brought, and let's say midway through the litigation, the opposing attorneys who were trying to record a deed of trust against their own client's property for attorney's fees, they actually recorded against the subject property. So now you have 33-420 lien claims that are brought into the lawsuit. Well, those claims are clearly separate and distinct from the quiet title claims, and I would agree in that case that in terms of determining attorney's fees, those claims would have to be dealt with separately. But here, that's not what we have. We have related legal theories all operating under the same operative facts, and I think China Doll does draw that distinction when you're dealing with claims arising out of the same facts that are involve related or alternative legal theories, and when you have separate and distinct claims.
Okay. Turning to the amount, couldn't the court have found, or shouldn't the court have found that your client was in error in submitting claims for all fees that were? Because you would agree that you are not entitled to recover fees on the tort claim, correct?
I don't necessarily agree with that, Judge, because there is case law that says that, which we've cited to, that says even on related or alternative theories of relief, you can recover if you accomplish the result in the litigation. And just for example, Judge, some of the claims were to a certain extent alternatively pled. So defense to adverse possession is that the party seeking adverse possession was provided with permission to utilize the property. Well, the elements for trespass, which was one of the claims in this case, is that you did not have permission. So so to a certain extent, some of these claims were alternatively pled, but there is a lot of case law we've cited to in our brief that states that when you're dealing with related legal theories, the attorney doesn't have an obligation to separate each entry based on claim-by-claim basis. And I even have the China Doll case right here. I can read you the relevant clause from the case. It states, on the other hand, one claim...
Is this China Doll?
Yeah.
Okay.
It just says, one claim for relief may involve related legal theories. Much of counsel's time will be devoted generally to the litigation as a whole, making it difficult to divide the hours expended on a claim-by-claim basis. Thus, where a party has accomplished the result sought in the litigation, fees should be awarded for time spent even on unsuccessful legal theories. Also, judges...
Remind me of the facts of China Doll. Was that a combined tort and contract case?
That was where a landlord brought an action against a tenant seeking to terminate the lease and damages for an alleged oral agreement to mutually cancel the lease. I'm not.
I think those claims all arose out of contract. I mean, arguably.
They did, but it's the same. Same principle.
This area of the LI is murky because you have cases where you have torts and then breach of contract. And I'm talking 12-341-01 analysis. I'm not aware of any case that says that you can obtain on a clear case of negligence. I'm not talking about breach of the implied covenant, good faith and fair dealing. Okay, bad faith. I'm not talking about that. But if it's a personal injury claim, clearly if and tied together with a breach of contract, I'm not aware of any case in Arizona that says you can recover any attorney's fees for litigating that personal injury claim.
Well, is it interwoven with the contract claim? I agree. If it's not interwoven with the contract claim or inextricably intertwined, or however the case law parses the language, I would agree with that.
How is the private nuisance here claim intertwined with the adverse possession?
Because in the pre-litigation quiet title claim, in the quiet title letter, the Cook claimed that he had been maintaining the subject property for 20 years, planting cacti, and he had been taking care of the property because Meadows had not. So that was essentially his claim for adverse possession. And the private nuisance claim just said, hey, look, because it's the court awarded Grebe the property, you need to clean up the property. That's all that was sought through the private nuisance claim, which was directly related to the adverse possession claim.
But had it been just a private nuisance claim and Mr. Cook had prevailed, neither party would have been able to recover.
I would agree with that, yes. Also, Judge, I think the more important point here is the legal standard on appeal. There's no specific entries that either at the lower court level or here that Cook has pointed to that are improper, which is a requirement. It's not found in the objection at the lower court. Under China Doll, Meadows and Grebe met the standards for an affidavit for attorney's fees. They had the contemporaneous billing sheets, the lawyer providing the services, the hourly rate, and a description of the time spent. And there was no objection by Cook to any of that. And the court did substantially discount the attorney's fees. And this court has to affirm an attorney's fees award if it has any reasonable basis. And so based on this record, I don't think this court has the ability to say that the trial court abused its discretion in awarding 60% or 58% of the attorney's fees sought. This case was principally driven by adverse possession and quiet title claims. That's what the vast majority of the litigation was spent on. And the court presided over the entirety of the litigation. He was in the best position to make those calls as to what to award and so forth. So, no other questions?
Questions? Okay, all right.
One couple other comments actually, since I have a few minutes.
Yeah.
So, not only did the pre-litigation quiet title demand letters reveal that the quiet title claims drove the entire lawsuit, there was a settlement exchange late in the case in which the Meadows and Grebe offered to waive all of their damages. So the trespass damages, that's not what drove the lawsuit, and you could see that in the settlement exchanges. It was really that Cook wanted the jury to decide his adverse possession claim, and that correspondence was before the trial judge when he awarded attorney's fees, and Cook didn't dispute those exchanges. That's one of the factors under associated indemnity is what settlement exchanges took place. Again, there's been no allegation by Cook that any task took an unreasonable amount of time or that a prudent lawyer wouldn't have undertaken any particular task. there was no objection to that at the lower court level or here. And that is all I have. Thank you.
Thank you.
Darrell Wilson for the appellant. The objection to the specific time entries. The problem with objecting to that is if you don't know what work was included in them, how can you object to them? If I don't know if he's working on the motion for summary judgment related to the quiet title action or it's the motion for summary judgment on the tort action, how can I object? I don't have a basis. And in China Doll, it specifically says the fee application must be in sufficient detail to enable the court to assess the reasonableness of the time incurred. Well, you can't determine if it's reasonable if you don't know what the time was incurred doing. I agree that there, I don't have any problem with the hours, the amount of hours he billed or the hourly rate. Frankly, I wish I was billing his hourly rate, but I don't begrudge him that. So I'm not objecting to that. It's all based on what were these claims for, or what was this work for. And it's also important that about where Mr. Gottlieb left off in China Doll, it says where a party achieved only partial or limited success, however, it would be unreasonable to award compensation for all the hours expended, including time spent on the unsuccessful issues or claims. The pre-litigation demand, you're required to send the letter for 12-1103, just like you're required for court jurisdiction to send a demand letter to a municipality or state agency, and you're required under the statutes in the construction defect cases to send a pre-litigation demand letter, and you aren't required to put everything in there. You are simply required to put them on notice that, hey, I have claims, and that's what a pre-litigation demand letter is for. So the fact that all these other claims, the private nuisance claim wasn't put in there, it was put in the original complaint. And it was a claim standing by itself, and there's different elements. Adverse possession relates to you using someone else's property. Private nuisance is you're on your own property, but that other property is interfering with my use of my own property. So they're distinctly different claims. Percentage of success, totality of litigation. Okay, the award was approximately 60% of what they appellees requested. Well, Cook won 4 out of 6, if you count the two claims as title claims as separate. So that's 66%. And if you count the title claims as one, which really one is a claim and one's a defense, then Cook prevailed on 80% of the claims. So there's no, and I realize I have a high bar here because you guys don't like attorney's fees appeals, but there has to be a reasonable basis, and you can't sit down and do the math. There's no logical reason for that amount. And so based on that, I don't believe that there was a reasonable basis, and I think that the court should find that.
So you would have us craft a algebraic equation that said if you're going to use the totality of the circumstances, then you really have to look at under 1103B who won and who lost what.
Yeah, that's basically kind of what the courts already do in the contract context. They do a math problem on if you have money claims and it's you assert a claim and then you get a counterclaim who prevailed more.
Basically, kind of, sort of. It's all pretty fuzzy.
It's a
little fuzzy.
As a trial judge, I know it was very fuzzy.
Yeah, and
there was no algebra involved.
Yeah. Okay, my dad's here, and he's was a math teacher, so let's not do math.
Oh, you're in trouble.
But I think that regardless of what the court decides, it is important to publish the opinion because there is a lot of fuzziness. And even under 12-341-01, there's some weird rulings that come out from the court. And I know as when you're advising a client, hey, here's your risks going forward, at some point in time, a lot of these claims, it comes down to the fees. And if you're at the fees and you can't properly evaluate what the judge is going to do on fees, then how can you can't really provide a clear advisement to the to your clients. And with that, unless you have further questions, I'll conclude my remarks. Thank you.
Counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We'll take a brief recess to prepare the courtroom for the next argument.